really excited, to hear from the speakers, and thanks to everybody who's attending. I'll quickly introduce the people who are coming up next. James Farrar is the founder and director of WorkerInfo Exchange, an organization which has helped set up. It's set up to help gig and platform workers secure their data rights under the European Union's General Data Protection Regulation. Meera Joshi is former chair and CEO of New York City's Taxi Limousine Commission from 2014 to 2019. It oversaw the city's overhaul and regulation of app-based ride-hail services. Currently, she's the New York general manager of Sam Schwartz, which is a transportation consulting firm. Zephyr Teachout is a professor of law at Fordham Law School. She was candidate for New York Attorney General and Governor. And this year she wrote Broke 'em Up, which is a book diagnosing the problems caused by oligopolies and monopolies across various spheres of society. Valerio de Stefano is a research professor of labor law at KU Leuven in Belgium. And that's where he focuses on employment, non-standard forms of employment, the platform economy, labor rights, and the intersection and the ways in which technology can affect all of these. And currently he's also an editorial advisor at International Labor Review and a member of the ILERA, International Labor and Employment Relations Association. And I'm Ed. I'm a journalist at Vice. And I'll just be moderating the discussion here, and I'll let the speakers take it away.
Okay, shall I go first? Yep, okay. All right. If you don't mind, I'm going to share some slides if I might do that. If I don't bore everybody to death doing that. If I can just figure out how to do it. Okay, hopefully you can share you can see my screen. Okay, so my name is James Farrar. I'm from WorkerInfo Exchange, and I've got 5 minutes really to set out my case. And I've also got an insurance plan that if this presentation doesn't go well, I'm going to blame it on the question that I was asked, because I think the question that I was asked was actually the wrong question. Why do we need to change the rules of access to data for workers? Well, the simple answer is getting access and control over your data. The most important thing, the only thing that will save us in the long run, is we can build collective bargaining power. Of course, we can do other things legally as well. We can make the case for regulatory intervention that supports us, whether it's transport, police, employment law, and so on, and we can protect and enhance our statutory rights. But the thing that I've learned over the years, of the 5 years of doing this, and learned it painfully, is that we'll never change anything. I think this mirrors what Deborah was just saying, unless we really build collective power together. And I believe getting access and control over our data is the single most important way of doing that, because a platform creates this relationship, this one-to-many relationship, this asymmetry in power, and we've got to somehow rebalance that. And the only way we can really do that in the long run is getting control over our data. But where I'm going to disagree with the question a little bit is that it isn't just about access to data. It's much more than that, and it's also much more simple and much more fundamental. 100 years ago or more, workers were standing outside factory gates, fighting as a collective for access to management decision, a seat at the table, participation. Well, we're doing the same thing. We're standing outside the factory gates of this platform in the cloud, and we are demanding access to it. We're demanding transparency over management decision. What does that look like? Those look like algorithms. What is an algorithm? It's simply a recipe, just like in a cookbook. It's a recipe of management instruction. It's nothing more than that. It's an expression of management instruction. production. And we are demanding transparency over that, as well as some control over that management decision. So in other words, all we're doing today with platforms in the cloud is what we did 100 years ago as trade unionists, as Deborah's been talking about in Tolpuddle and elsewhere. There's nothing more to it than that. So it isn't just about access to data, it's about access to and control and participation and transparency of management decision. And I'm going to set out 3 very quick scenarios of what that looks like in our situation working for gig platforms like Uber. It's about performance management decision, it's about work allocation decision, and it's even about decisions over dismissals. So performance management, I've been involved in a case and that was started here in the United Kingdom for worker rights with Uber, and it's just before the Supreme Court now. We're waiting for a decision. GMB started that back in 2015. Mick Ricks is on the call, so a shout out and thank you to GMB for getting behind that case early, before we even really, I think, fully understood what we were dealing with. But here's hidden performance management. This was something that was, I think, disclosed to us by mistake in that employment tribunal. I turned back a job to Uber. As you can see, it was 14 minutes to pick up. And I just said, that's uneconomic. I can't make money doing that. And I was given an electronic tag of negative attitude. Now, I don't know how that tag has been processed, but you can be sure it is. And we've got a case under GDPR in front of the courts in the Netherlands on December 16th, where we're going to actually find out the answer to that question. How are these performance factors, this profile that I know exists, that we have evidence of it exists, how is it being used in other decisions such as work allocation? So Uber, all they tell us at the moment about work allocation, which is an automated decision, is that the closest person gets the job, or the closest person within a batch situation in a neighborhood gets the job. Now, if you believe that is all that goes into the decision making about allocation of work, then I've got some land to sell you. Give me a message and I'll cut you a good deal. What does Ola say about it? Much, much more. What goes into the automated decision about who gets the work and who doesn't? Your prior performance at work. You even have a fraud probability score for every single driver, but we don't know what that is. I mean, what's my fraud probability score? Maybe I'm 98% fraud, 50% fraud. I don't know. Gender. They will derive, not that you've disclosed it to them, they will derive the gender of you and the passenger and make some decisions under the ambit of safety and security about that. Now, I don't trust somebody like Ola with that, because when they first came to the United Kingdom, they had a policy and they were warning women to use their prudence about accepting rides on their platform in the United Kingdom. They quickly changed it after we pointed it out to them, but it gives you a sense that there isn't really great thinking going into these so-called algorithms for automated decision-making. Your prior attention to management, your ratings, and so on. So bear in mind that this is a company that says this is just a simple work platform that's allocating work in an open market situation, but you are being performance managed. We need to know much more about that. And finally, about firing, about being deactivated. So people are being deactivated all the time now for fraudulent activity. Now, this isn't criminal fraud or financial fraud. This is dressed up fraud as in fraudulent use of the app. You didn't use the app in the way that we wanted you to use the app, and that you maybe have used your discretion to turn down work. And so we're ending the partnership, but it's not Uber ending the partnership, it's the community that's ending the partnership, which this is all nonsense, of course, and it's a reason why we must have greater access to these types of automated decision making. What's the battleground look like for access to data and these management decisions? Well, on the green step, this is the data we put into the black box ourselves. There can be no argument, it exists. We know it does because we put it in. There is the orange box, which is what the machine observes about us at work, our logged in time, our customer ratings, our GPS, our telematics. But then critically, the inference data, the profiling. What kind of a worker are we? We're entitled to all of this data, but I'm afraid we have to fight to get access to it. It's important, as Deborah says, because it isn't just about us in the gig economy. You know, there's a whole field of contingent labor. If you look at the big four, this is a sales pitch from Ernst & Young about the benefits of using an external workforce. What is that? That is just the gig economy writ large for the corporate sector. And look at the things that they think are great benefits. No employee protection laws, no protection against dismissal, no continued remuneration. This is the future of work in the digital digitization of work if we don't get our act together. We are simply the canaries in the coal mine. The digital workplace needs to be unionized, and we need greater worker control of it, or if not, this is our future. So data is power. Why do we need access? We need to build collective power. We need to make the case for regulatory intervention. We need to enhance and protect the rights we've got. So my call to action is collectivism is a team sport. We need to work together. We can't expect miracles in courtrooms alone. We need to work together to build our collective power. We need to do that by reclaiming our data and also demanding control over management decision, automated management decision. And there's a link for a crowd justice. We're trying to have this battle against Uber. We've raised a princely 500 quid. So if you could share that on Twitter and elsewhere, we'd be grateful. But also join us, join this battle. We're not fighting this just for WorkerInfo Exchange or for one union. This is for everybody. So please get behind us, support us in this, and we'll take it from there. Okay, I think I better stop. I think it may be over my time. Thank you very much. Back to you, Ed.
Thank you for that. I think up next, Meera.
Good morning, everyone, and thank you, James, for the visuals, because it's always important to see what the data looks like in reality and the tracking in reality. So I just want to present sort of the regulators and the city's perspective of the importance of data access for municipalities. They could be state or local governments. And I'm going to go through some points, and I think you can sort of change the order depending on your interest, but all of them are pretty fundamental as to why this access is really vital for the survival of cities and the people that live in them, including, and in large part, the drivers that live and work in cities and municipalities. So one is, we have to, as regulators, as government entities, look at what the results are. So there's a booming gig economy. It creates work of some sort for lots and lots of people that live in our communities. How does it look in reality? And what we found in New York City, and what I think cities are finding all over the world, and I say cities, but let that be used as a more general characterization. It's just a default that I go to. What it looks like is large groups of people working for very little money, long hours, and very sporadic ability to understand whether they'll have work the next day, the next month, hard to plan, and very unstable work conditions. That's what it looks like. And so the role of this regulator is setting the standards of what it should look like. What do we as a municipality, what do we want to support? And I think one of the key roles there is understanding what the landscape looks like. And I want to focus on something that James brought up, which is the power of data and the imbalance. When cities don't have access to some data about how these companies work in their cities and how workers are compensated and where they're working and how many hours they're working, it creates an incredible imbalance of power. And what you see happening in California right now with $184 gazillion, I can't even count that high, being used to fund Proposition 22, which is an effort to overturn the law that was passed that granted drivers employee status, you see where this imbalance of data is most powerful. The message that is portrayed there is drivers want flexibility. Do not make them employees. If you make them employees, they'll lose the ability to be flexible. They'll lose this wonderful part-time status that so many of them enjoy. but the data would show you otherwise. The data in Seattle and New York and places where we've gathered it shows that yes, there are a lot of part-time drivers. They may actually represent more than the majority, but the majority of the work, the trips that every passengers are taking every day, 8 times out of 10 are going to be done by a full-time driver. So though there may be a majority in number of part-time drivers, there's actually a majority of the work and the actual services being provided by full-time drivers whose rights and compensation is unexamined without data access. And that is just one example of how the narrative can be so powerfully changed if cities cannot combat those remarks with actual data. And I'll give you a flip side of that. In New York City, we got data about how much drivers earned, and we were able to pass laws to protect and create a floor on drivers' earnings. But one of the most important points that came out through looking at that data was the vast number of drivers that make less than the approximate of minimum wage. That number, that percentage is 96%. And no matter how much money the companies put into lobbying against efforts to enact a minimum pay standard, that fact, 96% of your workers, and at that time it's about 90,000 workers in New York City, the numbers come down due to COVID, made less than minimum wage. Now, you can't walk away from that. You can't walk away from that as a politician, as a regulator, as anyone who cares about the communities they live in. And the companies were without the ability to refute it because it was based on the data that they produce. And so I call that out because you're in a battle often against highly funded companies that have a tremendous lobbying power. And on the other side, you have entities, whether they be driver groups, labor advocates, or cities that are just, they don't have $1 gazillion. But when you have a data point that you can make public and raise awareness to the public and politicians about the exact state, you have one of the most powerful weapons, and one that actually, you know, money can't buy. It's sort of the truth. So I put that out there because we are in the midst of seeing battles being played out and the possibility of them being lost because of this imbalance of data. And I use California and Proposition 22 as an example, but we have the same battles that are imminent in Seattle, where they are also pushing for driver pay protection, and the companies have funded sort of alternate studies on what exactly the circumstances of drivers are. And Seattle is not equipped the way New York was with full access to driver earnings, and is therefore at a disadvantage in responding to those arguments, but not without assets, which they've artfully used, and I applaud them for it. I also want to point out something else that I found in my experience in working in this field as another data access point that puts cities, driver groups, and labor advocates at a sincere disadvantage. When you sign up to work for an Uber, Lyft, Ola, you give them your cell phone number and your email address. And in doing that, every time they have an agenda to push, they have a way to message that agenda. They have a way to try to garner your support, and they have a way to characterize, you know, maybe it's a political decision or a regulatory decision that's upcoming. And the drivers get that information, but they don't get the flip side. So unless the city has the same ability to communicate with drivers, labor advocates have the same ability to communicate with drivers, and drivers groups have the same ability to communicate with drivers, they will constantly be at a disadvantage. And I know from my experience in New York, the fact that we licensed all of these drivers, so we actually had their email and telephone numbers, we were able to alert them to upcoming critical decisions. And then for the first time in the history of sort of our regulatory environment, hundreds of drivers were able to show up at hearings and give real testimony about their real life experiences and their economic predicaments. And had we not been able to reach those drivers, they would have been voices that were unheard. And I say this because most drivers do not step forward to explain exactly what's going on. They don't have the time and they don't have the luxury. And they may not know what's going on in a political landscape. So in addition to data about how much drivers are making, where they're making their trips, how frequently they're working, and how much they're not working, but they're sitting around in a car waiting for a passenger but are uncompensated, it's important to understand how do we actually contact this group in a way that's meaningful so that they can have a real voice, because they surely want it but are often unable to get the information about what's going on. And I want to talk a little bit to end on, you know, what James touched on is a lot of management decisions, and what regulators can do, and I urge that regulators work together to do this, because us working in silos, it works to the company's advantages. They can pit one regulator against the other. So the more we talk and in groups like this, the better off we all are. But there's certain things that we see the results of on city streets. Response time and utilization are two things I'm going to put out there that are intertwined, that are important. So how long does it take a passenger to get a driver to appear on site for them for a pickup? And how often are drivers sitting around waiting for a passenger dispatch? Now they're intertwined because the companies would like that response time to be minimal. And if it's minimal, that means there's lots of drivers sitting around at the ready, not getting paid, congesting streets, not earning money, and otherwise sort of not attending to their life duties. And so understanding that utilization of drivers and how much downtime they have is really important to understanding the driver economics. And as a city, it's understanding sort of the balance of where do we want to tax these companies? Where do we want to ensure that they're adding to the revenue of the city for use of the city streets and for really abuse of drivers' time if they're actually not being compensated? And so one other fact that I think the data that we were able to get in New York City that I think is really important is and this is similar to Seattle, which has recently undergone this same exercise, is how much of the time out of every hour is a driver uncompensated and waiting? And in New York City it was 40%. And I think that's another stark data point that can be used in discussions and in pushback against companies, either flat out denial to provide data or push for legislation that is not in the best interest of drivers. So I'm going to leave you with that. And one final note, there is often a tension and a real tension between cities getting data and privacy and freedom of information. And there are genuine issues there that can be resolved and need to be thought through and resolved. But I do warn against companies understanding that there are issues and taking advantage of that by sort of pitting those two groups against each other. And I've seen it happen repeatedly where there's genuine privacy issues and groups that are genuinely interested in resolving them from a privacy and freedom of information front want to find resolutions, but they're fed information by the companies about what cities are actually asking for, to the detriment of furthering that conversation to resolutions. So I hope that in convenings like this, these groups can come together and really work on solutions that work for both, because there certainly are, and the data often that cities need is only one small, very small slice of the information that the companies collect. And so that should always be kept in mind. So thank you for your time. I look forward to questions and also the breakout groups where we can get into a little more details about these subjects. Thank you.
Thank you for that, Meera. Next, we can have Zephyr teach and lay out her opening statement.
Thank you so much. Thank you for that incredible presentation, Meera and James and Deborah. Can you all hear me? Okay, good. I think this is one of the most important democratic conversations to be having globally and in this country. I come at this as a democracy activist and see what is happening with Uber drivers, not to be just about the horrific conditions of Uber drivers, but as James indicated, about the future of the nature of work, and that necessarily means the future of the nature of democracy. And I just want to follow up with agreeing and disagreeing with something that James said. James said that it is essential to build collective power. And there's no way to address these fundamental issues without building collective power, and I could not agree more. But the other side of that is destroying illegitimate corporate power. So in order to build collective power, we also need to look at the other side of the equation. In other words, an essential part of getting to a place where workers have dignity and freedom and decent pay and benefits requires anti-monopoly work. Over the last 40 years, we have seen a radical collapse in the number of corporations, an extraordinary 40-year global merger wave. There have been over 500,000 mergers in the last 11 years alone globally. And there's very good evidence that this merger wave is a major driver in inequality. Recent research in the United States suggests that it is a $15,000 per year, sorry, $14,000 per year transfer from workers to investors because of concentration in our country. So thinking about what $15,000 means on top of a $35,000 a year per worker, not per family, per worker. It's an extraordinary driver of inequality. And for those of you who are working in this field, you understand how that works, that when you are a worker or a union fighting against one company or two companies or three companies, your relative power is far weaker than when you have the option to leave. You can look at the recent great examples of successful labor organizing, for instance, against Target, which got Target to drop abusive cleaning contractors because the cleaning contracting industry is actually fairly decentralized. It's one of the industries that has more decentralization because they had the leverage to say, leave this one and go elsewhere. When you have the kind of concentration that you have in the driver industry, it's incredibly hard to actually beat them without actually going at the root of their power. And it is not a surprise that Uber has gone after the key anti-monopoly statutes. The 1934 LaGuardia taxi law has in its statute, the taxi cab industry must be safeguarded against monopolistic control, because in the 30s, you saw this crowded streets, congestion, and incredibly poor driver pay. And one of LaGuardia's responses was to decentralize private power so that, drivers had relatively more power. So there's a long history of understanding that relative power is absolutely essential to addressing these issues. So I want to suggest that one of the ways to think about this is one of my favorite sayings is, if you have a problem you can't solve, make it bigger. Is to understand that the scope of the issue is even bigger than what we think of traditionally as the gig economy. That chicken farmers are subject to the platform of Tyson, and you've seen a radical drop in their relative pay. Amazon sellers are subject to the platform of Amazon. They're small business owners, but they're dealing with the platform economy. And we have to understand that workers who work for Amazon sellers are subject to Amazon's platform economy, because Amazon does exactly what James was talking about in terms of black box algorithms rewarding, sucking out value from companies, using its platform power to spy into those companies and essentially force them to reduce their wages to their own workers. We certainly know that restaurants and then the workers who work for restaurants are then living in a platform economy. Franchisees are living in a platform economy. And while I do think that tech or the surveillance capacity and the capacity to abusively experiment on and suck out and extract value is totally different because of the nature of tech. I think it's actually sometimes helpful to get outside of tech and understand that this is not technologically determined, and that this is a business model that we can ban. And a way to ban the business model is to ban forms of monopolization across the board. So look forward to the full conversation, but I hope that we include anti-monopoly along with labor power and understand how those two are deeply connected.
Oh, thank you for that, Zephyr. And last, close us out, Valerio.
Thank you, Erlo, and thank you, everyone, for inviting me and for the great presentation before. I'm an employment lawyer, and I was asked for this initial panel to say what is important when we talk about the gig economy from an employment law perspective. And of course, there's a bunch of possible issues to touch upon, but I think there's four main aspects that I would like to talk about today. And the first one is the question, of course, of employment status that has been touched upon by some of the speakers before me. And of course, why it is important, because our labor laws tend to be constructed in a way that it's like an all-in pitch. You either are protected by employment law or you're not protected by employment law. And if you are an employee, you are protected by employment law. If you're self-employed, you're not. There are systems in which there's third categories of workers, and the UK, where James lives, is one of those. Italy, where I come from, is one of those. We can discuss later on maybe why I don't think a third category of worker is a solution at all. But for the moment, let's say that there is like this divide between you get the rights, the protection employment laws gives to employees or not. And when do you get those protections is when you meet the criteria that define employment and employment contract and employment relationship. Now, not one of the problem with that is that some of the indicators that define what employees have a lot to do with the industrial model of production, or at least in the mind of judges, in the mind of regulators, they have. Even if those indicators are not written in the law, many judges, many regulators think that if you don't work 9 to 5, you cannot be an employee. Now, that is a wrong assumption. That is not based on any statutory definition of employee I know of. But it's still a very strong assumption that courts and regulators make. And this is where Uber, Lyft, Deliveroo try to hit most early. They say, if you are flexible, you cannot be an employee. If you are an employee, you cannot be flexible. And so this is why they pitch all this rhetoric again on flexibility. And if you're a flexible worker, you cannot get protection. This is not true. Many of the statutes we have around employment law around the world were specifically designed to protect also casual workers, to give a minimum wage also to casual workers, not to exclude them from employment protection. This problem of some of the indicators that in the mind of the regulators and the courts are old-fashioned, while at the same time they're not. We see many courts around the world going around this. And as now that in California, for instance, the regulators try to come with a definition of who is an employee who should be covered by employment laws that doesn't have much to do with this flexibility thing. This is where Uber and Lyft are investing all the money to convince regulators, but also the public more in general and workers, that they cannot have flexible employment and protection at the same time, which is basically false. The second problem I see is that self-employed per se is not protected enough. We are not in a situation in which, like it was decades ago, where we could assume safely that most of the self-employed people we see in the labor market are strong enough, strong bargaining power, that they can defend themselves without the protection of the law. We see that there are more and more self-employed that are vulnerable, that don't have a lot of bargaining power, and still, so there's a lot of heterogeneity in self-employment. And at the same time, the law assumes that self-employed people don't need any protection before the law. So they are excluded from freedom of association and the right to bargain collectively in many countries in the world. And if they try to bargain collectively, they get busted by competition authorities, which it's a sort of like an ironic thing that the competition authority don't go after Uber or Lyft, and they go after the Uber drivers that unionize and try to bargain collectively, because the antitrust authority says, so if you do that, you are an undertaking. Even if you drive around with your car, you are a small enterprise, and so you cannot coalesce with your fellow workers, which of course doesn't make sense at all, but it's what is happening at the moment. At the same time, self-employed people are excluded from strong anti-discrimination protection, such as, for instance, Title VII of the Civil Rights Act in the United States, and many other anti-discrimination protection around the world. So there's too low protection of many self-employed in our labor markets at the moment. A third problem, if we talk about online platform work, so we're not talking about Uber or Lyft or Deliveroo, but we're talking about the Amazon Mechanical Turk, Clickworker, Upwork, is that the law is not perfectly designed to protect people that work from one country for a platform that sits in another country, maybe for a customer or client that sits in a even different country. The law is designed to protect employees, but when it comes to the self-employed, again, most of the regulation is left to basically the choice of the parties. And in the case of platforms, this is the choice of the platform. So you have to litigate against a company in a completely different country if you want to get protection. Now, when it comes to geographically localized work, even when the platforms try to say, okay, you should sue me in the Netherlands if you work in the UK, the court say, no, well, our employment laws don't work like this. But if you, I assume that James had to go before the Netherlands to sue them on privacy rights, because this doesn't work all the time. So it's very, very complicated if you want to have meaningful access to justice to litigate in a country different from your own. So this is a problem that needs to be faced. And the fourth and final problem, I cannot reiterate enough what James already said, is about data ownership, data access, who has access to this data, and how worker can claim ownership and collective ownership of the data they produce for the platforms. And I stop here.
Thank you for that, Valerio. I think now, we have a few minutes to go into Q&A. I think people have asked a couple of questions, so we'll probably tackle them one by one. I think the first one I'm trying to find here is from Nicolas. And it's, what are the examples where municipal or national regulators mandated data sharing or opening up relevant information on labor conditions? And what are the reasons why this has not happened on a larger scale so far? Yeah, go ahead, Meera.
So the examples in the United States are New York City, where in 2017, 2018, we required 4 weeks of data on driver pay from the companies, one representing each season. We analyzed it, determined that drivers were making 96% of them under minimum wage. We formulated a policy which set a minimum pay for minute and mile. And then we passed that policy, and the pay protection went into place in early 2019, along with data requirements. So on an ongoing basis, data about driver earnings and driver hours must be submitted to the New York City Taxi and Limousine Commission. The next example, and I think Karem is on this call too, is in Seattle, where that's underway as we speak. They passed an ordinance requiring pay protection, and the upcoming ordinance, which I think Karem is also on this call, can give you the details, will have data requirements as well. Chicago is another example of where there are data requirements in place. They recently amended them to require driver pay information. I think that's a precursor to doing the work that's been done in New York City and in Seattle to enact driver pay policy. And I think when it comes to the question of why hasn't this been done anywhere else, it comes down to two intertwined reasons. There's incredible lobbying power on part of the companies about, if you do this, this parade of horribles will happen. And the parade of horribles are, one, you're wrong. Workers, like flexibility, and driver pay protection undermines flexibility. Two, we'll have to kick all these drivers off because it'll cost us more money to operate, and we won't be able to have so many drivers on anymore, which they will articulate in a different way than I just did. And three, this is just wrong-headed and foolish, and it's not based in data. And by the way, we won't give you the data to do your own verification about whether it's based in data or not. And I don't want to undersell the power of those arguments, because the fact that it's New York, Seattle, and maybe Chicago is pretty stark, seeing as this is a nationwide condition. I would love to see this work happening in a city like London. I think James is, you have the community there to support it. You have the evidence there to support the circumstances around driver pay. And I think you also have a lot of political will to support it. But it is getting the sort of backbone together with legislatures and politicians to do the work around the data gathering that really is the stumbling block and the challenge. And I say coming together internationally as regulators and as policymakers only makes that ability to overcome those challenges that much easier, because we're speaking with one voice and we're a broader group.
Could I add something to that, if I may? James Farrar here. I think what Meera did in New York is really exceptional and world leading, and more cities should do it. But sadly, it has been the exception. In the United Kingdom, 2 years ago, Dara Khosrowshahi met with the Transport Minister, and we have the minutes under freedom of information from that. And the ministry raised the question with Dara about how so much transport data was locked up on a private platform. And there really was no good answer from Uber except, well, we'll do the right thing. So there hasn't been a push to share that data, and there hasn't been a push from either the central government or local government to demand it. And part of the reason for that could be that a lot of local municipal authorities are just broke. Meera and I went to visit a city, which I won't name, and you may remember this conversation, but it was authority speaking to authority, and I think they forgot I was in the room. And what that local authority said was they had to pick their battles with a platform like Uber very carefully, because they just simply didn't have the budget to litigate, to enforce. And the reality then is that instead of dealing with Uber as the symptom or as the cause of the problem, they go after Uber drivers as the symptom. And so we have a very harsh regulatory environment against Uber drivers, and an unwillingness to protect them and to understand that they are being exploited. Now, what we have seen last week is that Uber is beginning to trade data for license or for favor. So it has an agreement with the police chiefs in 35 out of 46 police districts in the United Kingdom to share data. But if it's sharing that data, it's doing so without a warrant. So they can do that, and for the police asking for that data, it releases the police from, or they releases Uber from their obligations under the Data Protection Act. But best practice is for them to say, no, no, you need to have a warrant. And so we have a situation where, you know, the police are getting the data, but drivers are not being protected even when they're being assaulted. And cities are not protected drivers from being exploited either. And so we need a fair deal. If cities and police get the data, then they should do more to protect drivers. I'm afraid we're in a situation that everybody's empowered by data except the workers.
And just briefly, this is the kind of investigation that in the US we should be pushing the Bureau of Economics at the FTC to be doing. As well as local governments. This relates to this lack of resources at the local level. So this is part of when in the 1940s we built anti-monopoly regimes. The investigative arm was a key part of those anti-monopoly regimes.